Rules Committee will come to order, and thank you very much for joining us again today. It's a bittersweet day for our country. Certainly it is for me as a Texan, and I want to start by, Bobby, how are you, sir? Chairman Walden. I want to start first by saying today that my thoughts and prayers are with the people of Sutherland Springs, which is near San Antonio. I grew up in San Antonio. And the people who were at this church were taken advantage of by a very sick, mean man, and my heart goes out to them. My heart goes out to all of us, but it goes out to them and their families. And I just spoke with Mrs. Slaughter, who would intend to not only be recognized for the purposes of expressing her mind on this, but I'm doing that also. And I would say to my friends from Sutherland Springs and San Antonio and Floresville, which is very near, as I told Congressman Cuellar, my hearts and prayers are with them. Today, the Rules Committee will be considering H.R. 3043, the Hydropower Policy Modernization Act of 2017. I can almost get that out, Greg. And H.R. 3441, the Save Local Businesses Act. 3043 modernizes federal regulatory permitting processes by designating the Federal Energy Regulatory Commission, known as FERC, as the lead agency for licensing hydropower projects. By streamlining the hydropower permitting licensing process, this legislation utilizes untapped resources to unleash American ingenuity, lower energy costs, and create well-paying jobs. I have been on, and I'll be corrected here, but on the most beautiful highway in America, which goes from Portland, Oregon, eastbound to Hood River, Oregon, into the Dalles. And it contains a huge number of these projects, hydro projects, and it, in fact, is a beautiful way and a great way to provide energy and power and natural resources. So, Mr. Walden, I'm delighted that you're here to talk to us about that. The second bill under consideration, H.R. 3441, was introduced by our very own member of the Rules Committee from Alabama, Mr. Byrne. In August 2015, the National Labor Relations Board placed itself squarely in the middle of the employer-employee relationship, creating what I think was confusion for workers, employees, and small business owners. The controversial 3-2 decision reversed nearly 30 years of labor law, which held that an employer needed to have actual or direct control over employees to be considered a joint employer. H.R. 3441 rolls back this controversial joint employer scheme that threatened, I think, not only jobs but job creation, and undermines the ability of not only small business, the employer, but also people, the American dream, to have a job. The bill amends the National Labor Relations Act and the Fair Labor Standards Act to clarify that 2 or more employees must have, and I quote here, actual, direct, and immediate, end of quote, control over employees to be considered joint employers. This legislation is a win. I think it's a win for small business, for employers, for franchisees, for restaurants and restaurateurs who many times have found themselves at the backside of this rule, and small business owners, including those from my hometown in Dallas, Texas. Many restaurateurs, the National Restaurant Association has been very vigorous in having their members not only meet with me, but to talk about the common sense related to these changes. So, without objection, before we go to Mrs. Slaughter here in just a second, I'd like to welcome the gentleman from Oregon, the young chairman of the Energy and Commerce Committee, my fellow Eagle Scout, and the gentleman from Illinois, my dear friend, Congressman Rush, to this first panel. We're delighted to have you both here at the Rules Committee to meet with us, and of course, Greg, you'll soon find out that one of your favorite members, the gentleman from Louisville, Texas, Dr. Michael Burgess, sits on this panel, so you'll think it's a home game. But in fact, we're delighted to have you here, and Mike always gets excited about looking forward to your testimony. So, without objection, anything you have in writing will be on the record. And before we move to our first panel, we will yield to the gentlewoman from New York, my very dear friend, the ranking member, Mrs. Slaughter.
I thank you, Mr. Chairman. I appreciate your letting me do this. This is something that's so embedded in my mind that I really have to speak on it today. Because yesterday we saw another shooting in a church. You know, I grew up most of my life believing that places of worship were sanctuaries. They even made movies about it in the old days. If you could make it to the church, you were going to live. Well, no more, no more. Families gathered together in a small Texas town, and a man with a gun went in and killed 26 of them, including an 18-month-old baby, and wounded 20 more. One family lost 8 of its cherished members. Think about it. We're about 2 or 3 weeks now away from Thanksgiving, and followed by Christmas. 8 people that they loved and cherished will not be there because this man had some kind of score to settle, or what, heaven knows what was in his mind to do that. But those killed in the attack equaled about 7% of the small town's entire population. The shooting at the First Baptist Church in Sutherland Springs was only one of 2 church shootings in America yesterday. In Fresno, California, an estranged husband shot his wife and her boyfriend as they left a Sunday morning mass. Shooting deaths happen so frequently that we don't even acknowledge or know about most of them. When something like what happened in Las Vegas or in Texas captures the nation's attention, all that we hear from the leaders of Congress and the president is just too soon to talk about it, as though it was some sort of breach of etiquette if we understand that these people are gone and are not coming back. That must be an NRA talking point. It seems that the NRA has become more powerful than religion and reason. I'm going to say that it's not too soon to talk about solutions. It is too late for that baby and the other 7 members of that family that are dead. It's too late for the families left behind to mourn their losses, but it's not too late to work together to stop these tragic murders. It does not have to be this way. Why don't we require verified background checks for all gun sales? Every indication that we have is this man had no right in the world to have a gun. Why do we let people that we know have mental illnesses buy guns? Why does the federal government prohibit the CDC, the Communicable Disease Center, from even researching gun violence? Can't even talk about it. We research vehicle fatalities and try to find ways to reduce them. Then we require manufacturers to create safer cars, and we prohibit people from driving while impaired or distracted. We prohibit speeding. These policies save lives, but we're not even allowed to talk about gun deaths in the United States Congress. And doctors, in the ACA bill was added, are not allowed to ask their patients if there are guns in the home. Over 500 people are unintentionally killed by guns every year. Now, why don't we require the gun manufacturers to only make guns that won't go off if they are accidentally dropped? Why don't we require that new guns can't fire when a magazine is removed, whether or not there is a bullet in the chamber, in order to reduce the accidental deaths? Why don't we require manufacturers to make guns that produce bullets traceable not only to the make and model of the gun, but to the exact gun? This would increase the threat of being caught when committing a gun crime and maybe deter some would-be criminals. Why don't we work toward technology that allows guns to only work in the hands of the rightful owner so that stolen guns become useless? Why don't we direct law enforcement to at least check in on people who buy excessive amounts of guns or ammunition, like the young man who shot up the theater in Aurora, Colorado? Why don't we direct law enforcement to check in on people who buy excessive amounts of gun and ammunition, who have a history of domestic violence and access to guns? Why don't we have a select committee on gun violence in the United States Congress? And good Lord, why have we not yet banned those bump stocks and devices like them that could be used in another Vegas-style attack any day of the week? And we're going to spend the bulk of this week debating bills on micro offerings and hydropower and joint employer rules. Well, that's good, but our citizens are not dying by the thousands because of regulations that balance energy projects and the environment. They are being killed by guns, by people committing crimes, by people who are mentally ill, through suicides and through guns going off by accident, or guns without gun locks on them in the home. I'll never forget the night, early in the morning, when this Congress banned the use of gun locks for no earthly reason that I know of except the NRA wanted it done. When are we going to take up some legislation to do something, anything, about gun violence in this country? I think it is as much of our part of our job as anything else we do. If people were being killed in large numbers for any other reason, believe me, we would be discussing it, we'd be talking about it, it would be all over, and we would do something about it. We did once. We took the automatic rifles off the street for about 10 years and then expired, and we were not able to get it back on. What earthly reason would a hunter want with an automatic gun? None. So this idea of being helpless in the face of this and it being too soon to talk about it, it is way too late, and we can't waste any more time. Thank you, Mr. Chairman. I yield back.
Yes, ma'am, and thank you very much. Does any other member wish to have time yielded to them for the purpose of speaking about the occurrences in Texas or the occurrences in California or Nevada? Las Vegas.
Name them. Newtown, Connecticut.
Yes, ma'am.
New York City. Where?
Yes, ma'am. Gentlemen, want more time?
Oh, thanks.
Okay. Thank you very much. Mr. Chairman, we're delighted that you're here. You brought with you Mr. Rush, who is a very eloquent, not only speaker, but I know a thoughtful and articulate member of your committee, and I'm delighted that you're here. And the gentleman's now recognized, Mr. Chairman.
Mr. Chairman, thank you, and Ranking Member Slaughter, thank you. And we're delighted to be here today, and I'm delighted Mr. Rush is here. He's a very important and able-bodied member of our committee, does extraordinary work, and oftentimes it's in a bipartisan manner, and we're here together. Today, unfortunately, we didn't quite get there, but there's a lot of good work that we will present to you. Chairman Sessions, Ranking Member Slaughter, thank you for the opportunity to testify before the Rules Committee on H.R. 3043. This is the Hydropower Policy Modernization Act of 2017. Its legislation was introduced by the Energy and Commerce Committee member Kathy Morris Rogers out of the great Washington state. This legislation is the product, frankly, of years of work, much of which was agreed to on a bipartisan basis during the Energy Bill Conference negotiations last year. But unfortunately, that conference didn't quite make it across the finish line. So this year, we picked up where we left off, and we went through regular order in the Energy and Commerce Committee. We held legislative hearings and subcommittee and full committee markups on the bill. H.R. 3043 is truly bipartisan legislation. Through the committee process, we gathered input, we made some changes to address concerns that were raised of us, and in recognition of that effort, the bill was agreed to and reported out of committee by voice vote. At its core, H.R. 3043 would bring more certainty to the hydropower licensing process by strengthening the Federal Energy Regulatory Commission's role as the lead agency, requiring more timely decision-making and reducing duplicative oversight from the multiple federal and state agencies involved in these permitting processes. So one of the great advantages of living in my state of Oregon is the plentiful supply of affordable, reliable, clean, carbon-free hydropower. The dependable baseload power has helped drive development of everything from value-added agricultural processing to data centers, creating jobs along the Columbia River and throughout Oregon, and frankly, Washington as well. Hydropower is good for consumers' electric bill. However, in the Pacific Northwest and across the country, we're not taking full advantage of this carbon-free resource. The electricity generated from hydropower allows a diverse energy mix, which in turn increases our nation's energy security and its reliability. A recent Department of Energy report found the U.S. hydropower production could grow by almost 50% by the year 2050. This potential increase in hydropower production would boost job growth, it would increase economic investment, it would further facilitate the use of wind and other intermittent renewables, because hydropower can act like a water storage battery, if you will, and avoid emissions from other electric power sectors. There is tremendous opportunity to expand hydropower production. Less than 3% of the dams in the United States, approximately 2,200 dams, produce electricity, less than 3%. And by 2030, more than 400 existing projects with more than 17,000 megawatts of capacity will begin their relicensing process. Upgrading the performance of existing dams, utilizing existing non-powered dams, canals, and conduits would enable investments which would address aging dams and improve overall safety and energy production. Well, despite the numerous benefits of hydropower, the greatest impediment facing its growth is the regulatory process. You see, the licensing of new hydropower facilities and the relicensing of existing facilities is both costly and time-consuming. The process often requires 7 to 10 years to complete, and it costs tens of billions of dollars, all of which is borne by ratepayers. We can do better. With the hydropower licensing improvements in this bill, we can encourage investments in new hydropower infrastructure, which will benefit consumers with affordable electricity and expand the use of clean, renewable energy. Mr. Chairman, Ranking Member Slaughter, thanks again for the opportunity to testify. In closing, I just want to say that this legislation, the concepts in this legislation are supported by groups as far-ranging as the American Council on Renewable Energy, the American Public Power Association, the Business Council for Sustainable Energy, the Edison Electric Institute, the International Brotherhood of Boilermakers, the International Brotherhood of Electrical Workers, the International Federation of Professional and Technical Engineers, the Operating Engineers Union, the Large Public Power Council, the Laborers International Union, the National Hydropower Association, the National Rural Electric Co-op Association, the North American Building Trades Council, the United Association of Union Plumbers, Fitters, Welders, and Service Techs, and the United Brotherhood of Carpenters and Joiners of America. So it has broad-based union and industry support, and certainly from the electrical sector as well. With that, Mr. Chairman, I yield back the balance of my time and look forward to any questions the committee may have.
Chairman Walden, thank you very much. Mr. Rush, we're delighted that you're here, and more importantly, you look great. Gentleman's recognized.
Thank you, Mr. Chairman. I am delighted to be here. I am delighted to be the chairman of the school committee. I'm the chairman of the full committee, Congressman Walden. And Mr. Chairman, I must say that before I begin, Congresswoman Slaughter, I agree with everything that you said, the sentiment that you said, the spirit in which you said it, and I am too join you in being utterly outraged that here in this U.S. Congress, we can't do anything about our babies being killed. As you know, I had a son who was killed, shot down on the streets of Chicago some years back. And I am a pastor of a church. I preached yesterday, still before my congregation, and had to share the sentiments and the concerns of all those who sit in church thinking that that is the one place in America where we can be safe. So I do join you and support you and agree with everything that you said.
May I say something to Mr. Rush?
Excuse me just a moment.
All right.
Excuse me just a moment.
I just
Yes,
want to
ma'am.
respond to what
Yes,
he said.
ma'am.
I thank you so much for doing that. I think we need to ask ourselves seriously, is why do we allow somebody who's adjudicated to be mentally ill to make some point on people who are worshiping in a church or in a theater or in an elementary school? How long is that going to go on in America? We're the only country in the world that puts up with that, and it makes absolutely no sense. I read today that the new ambassador from Sweden is visiting Pennsylvania. Did you all see that in the paper today?
No.
She's trying to understand who we are and what happened to us, basically, I think. There's sometimes I honestly think we have a loss of reason.
Yes, ma'am.
But I don't know how anybody who loses a family member this way could ever forgive us for the days that go by and we do absolutely nothing. But thank you
Yes,
very
ma'am.
much.
Yes, ma'am. Mr. Chairman, simply stated, I respectfully request that this committee grant an open rule so that my democratic amendment in the nature of a substitute and other worthwhile amendments will be allowed in order. Mr. Chairman, while both sides of the aisle support hydropower, we tried to come to a bipartisan consensus at the committee level. Unfortunately, I cannot support H.R. 3043 in its current form. Mr. Chairman, members on the minority side have many objections to this bill due to its impact on tribal rights, as well as its effect on states' prerogatives under the Clean Water Act. Additionally, Mr. Chairman, H.R. 3043 expands and alters the trial-type hearing provisions of the Federal Power Act, essentially rigging the process in favor of industry by providing multiple new entry points to challenge conditions designed by federal resource agencies. Mr. Chairman, the threat of these timely and costly hearings may be used to coerce agencies to propose weaker conditions and at the very same time also shifts the venue of these hearings to FERC, which is another handout and hand over to industry. H.R. 3043 would not modernize or improve the hydropower licensing process, but rather it simply places private profits for industry over the public interest. Instead, Mr. Chairman, we need a more balanced approach, such as the one provided in my substitute amendment, which contained bipartisan provisions that were included in the hydropower package that both sides agreed to in committee in December of last year. My amendment also contains several provisions to improve the licensing process while also offering incentives to the hydropower industry. This substitute contains a requirement to set up a new licensing process, but unlike H.R. 3043, it protects the rights of federal resource agencies, the rights of states, and the rights of Indian tribes to impose conditions in accordance with modern environmental laws. My substitute, Mr. Chairman, also amends the definition of renewable energy to include all hydropower, just as H.R. 3043 does. However, it expands the goals for federal purchasing of renewable power beyond the 15% included in H.R. 3043 as an objective and not a mandate. Mr. Chairman, my amendment also contains a, quote, reward for early action, end of quote, provision that authorizes FERC to take into account a licensee's investment made over the course of their license in order to improve the efficiency or environmental performance of their hydropower facilities when selling the term of their new license. Mr. Chairman, in testimony before the Energy and Commerce Committee, we heard repeatedly that a major cause for all licensing delays was due to incomplete applications that do not include all the pertinent information that was necessary to ensure a decision. While H.R. 3043 does nothing, absolutely nothing, to address this issue, my substitute does so by directing FERC and other federal resource agencies to convene a negotiated rulemaking with all stakeholders to develop a process in which a completed license application will be evaluated and issued or denied within a period of not more than 3 years. Mr. Chairman, instead of kowtowing to the wishes of industry as H.R. 3043 does, I urge this committee to propose an open rule that will allow my substitute and other worthwhile amendments to be offered. And with that, Mr. Chairman, I respectfully yield back the balance of my time.
Thank you very much for your not only words, but your ability to effectively see this bill and offer critiquing of that. Mr. Chairman, is hydropower considered a green energy?
Well, I think it's considered green energy. The question is it considered renewable energy?
Okay, renewable.
And that's a matter of debate. I think when you look at it from a scientific basis, clearly it is. Water flows through, virtually no emissions occur, and energy is developed. Along the way, though, in an effort to try and encourage development of other types or even more hydro renewable energy, decisions have been made at state and federal level to say existing hydro does not count as renewable. The ultimate effect of that is diminishing the value of existing carbon-free hydropower. And that now is beginning to have problems in the marketplace as existing hydropower is diminished in its value because it's not technically renewable. It's causing market distortions. This
Is that a tax component?
No, it's just
what's an advantage or disadvantage of that, Mr.
Well, the
Chairman?
disadvantage would be if you're an entity that is required by other statutes, state or federal, to purchase renewable energy, and hydropower that existed prior to whatever date is not considered renewable, then that hydropower's value is diminished because it's not considered renewable, when in fact the renewable goal is to have renewable energy, and hydropower clearly is renewable energy. So it's, again, the government putting its thumb on a scale, and it didn't matter as much in the past as it does today. And for those of us in regions that have, we're kind of ahead of the curve in renewable energy creation, we got, well, you know, the federal government, no good deed goes unpunished. We get punished here in the Northwest because we were part of the great energy revolution of the 1930s, 40s, 50s, 60s, and into the 70s with hydropower dams on the Columbia and Snake River systems. We're not alone in that respect. So this legislation would say for federal purposes, at least, that power is renewable that is produced in the hydro systems in America.
The report that I've been provided from the committee, and by the way, I'd like to say that your staff director, this gentleman, Ray Baum, has been most instructive in helping not only our staff, but me to prepare for today's hearing. And Mr. Baum should be thanked for his participation.
You know, Mr. Chairman, if I might, he has an extraordinary background, not only as a country lawyer, but as an effective state legislator, a majority leader, and then under Democrat governors, both served on the Oregon Public Utility Commission and chaired the Oregon Public Utility Commission before finding a weak spot and coming back here to work for me in the Energy and
Well, everybody
Commerce
has
Committee.
weakness about them, I'm sure, but his expressions of support for public policy is what I found amazing. Mr. Chairman, on page 15 of the report, you don't need to go there, but it says, based on information from FERC about the potential cost of implementing the bill, CBO estimates that any incremental change in fees collected would be small. So we get more power at substantially lower cost. That more power would mean that it could increase substantially over the next few years by making modifications. And what we're trying to say here is you're empowering and encouraging us to do just that, get more for a better cost.
True, that's certainly a big portion of this bill, but also we want to have, we don't waive any of the environmental laws on the books, not the Endangered Species Act, not the Clean Water Act, none of that. All we're doing is trying to streamline a permitting process that today can take 7 to 10 years and cost tens of millions of dollars into something that's more reasonable and rational, still allowing the public to have a voice and a say, and proper reviews to be done. But today, these things get dragged out for a decade or more. And hydro holds a great opportunity for America to develop more renewable energy. As the committee report and other data show, there's enormous untapped potential on existing dams where you could add a hydro facility to it. There's one in my district, the Congress unanimously passed legislation a year or two ago that would allow for small-scale hydro on this little dam, be about 25 megawatts, not a lot, but guess what's right next to that is Facebook's data center, Apple's data center, others. They want to drive this non-polluting energy production. We can do that, but who wants to wait around 10 years to do that when we know how to, mechanically we know how to do this. They can do the studies in a timely manner, still consulting with all the affected parties. We can, this just modernize and improves an old statute that was built for a different era.
Well, I find that what you're trying to do here is get more for less. And Mr. Baum did a heck of a job at least telling me that as he went through this bill, that he felt like it'd be good for a lot of people who don't have to pay more and costs are not more.
And Mr. Chairman, we all know infrastructure matters this country, and that's why I think you see the list of names I read off of various building trades, unions, and others, very supportive of the concepts in our bill because they want to go to work, and we want them to go to work. And we need to expand our carbon-free renewable energy footprint in America. We can do that through this legislation, and so I think it's good all the way around.
Did I forget anything, Bobby?
Well, Mr. Chairman, yeah, I think that your questions, while pertinent, is not at the heart, does not
Not the heart of the matter? Okay.
Don't address the heart and matter of the bill that's before us. Mr. Chairman, that's not a member of this Congress who's not in favor of hydropower. The debate about whether it's renewable or non-renewable, and we that's a debate, but not for today. That's maybe a debate for another time. What we're talking about right now is governance. It's really about states' rights. Mr. Chairman, there are numerous entities that believe that this legislation could undermine their efforts to execute their responsibilities under the Clean Water Act. Some of these entities include the Western Governors Association, the Environmental Council of the States, the Association of Clean Water Administrators, the Association of State Wetland Managers, and the states of Maryland, Vermont, Washington, and California. And, Mr. Chairman, in addition, the Southern States Energy Board adopted a resolution in September opposing provisions of the bill that curtail state authority. Mr. Chairman, by shifting this, the power to execute the provision of this bill to FERC, an entity who has no experience at all legislation or enforcing environmental laws, wouldn't know the difference between an environmental law and telecommunications law. We're giving them the responsibility, the sole responsibility. And all the state agencies, all the Indian tribes, everybody has to submit to the authority of
Well,
FERC now.
I think you're right. I noticed also in here that it does require states, tribes to have to participate, and they even have to acknowledge they got invited to participate, which tells me that in the past, maybe they ignored an invitation. So I consider that very favorable.
I'm sure they're gonna have, they probably will participate, Mr. Chairman, and they're participating because according to the regs, they have to participate.
Yeah, well, maybe we forced them.
But, Mr. Chairman, just mere participation and no input is not the same thing. They don't have no input, they can't influence the decisions of FERC at all. So I just think, Mr. Chairman, what we're really doing now, we're really just eliminating states' abilities to firmly have a say about how they want the hydropower industry in their states to be governed.
Well,
Mr. Chairman?
Mr. Chairman Walden?
Yeah, I would just take some issue with that, as you might imagine, because we believe the bill actually encourages other agencies to participate in the review process
It
earlier.
mandates it, Mr. Chairman.
That's right, Mr. Chairman, rather than later in the process. The bill places a new requirement, as you so ably identified, on the Federal Energy Regulatory Commission to actually reach out, identify, and notify other agencies and Indian tribes of the opportunity to participate. That way, they can hopefully identify potential issues and resolve those and save money and time. So, and they still have to follow. FERC becomes a lead agency. Yes, somebody has to be in the lead here. That's actually the problem we're trying to solve.
Point.
And so the bill clearly says FERC shall establish a schedule in consultation with the appropriate federal agencies and Indian tribes that complies with applicable schedules established under federal and state law, and facilitates completion of federal and state agency studies. You notice I said federal and state agency studies, reviews, and any other procedures required prior to or concurrent with the preparation of the Commission's environmental documents as required under the National Environmental Policy Act. So the idea here is finally you have a lead agency, it's FERC, you had to name somebody. They have to reach out to all affected parties, state, federal, and tribal, say, what are you worried about? What are you concerned about? Develop in consultation with them a timeline that they're all agreed to operate under, and then they move forward under both federal and state law. We made sure and put in here a savings clause that none of this waives the Endangered Species Act, NEPA, these other things. So I think we found a sweet spot here that works to try and move the process forward, do process reform here, but still protect the rights of states, tribes, and other federal agencies to have a meaningful role in the discussion.
Well, I want to thank both of you for being here. I will tell you that I think that these projects, whether they're in Nevada or whether they're in the great state of Oregon, represent great things for consumers and clean energy, and I quite honestly wish we had them in Texas. Chairman Cole?
Thank you, Mr. Chairman. I appreciate it. Appreciate both.
By the way, big game this weekend. You
Was
won.
a very, I noticed Mr.
You know,
Lucas
he
didn't show back up.
Didn't show.
But I'll see him later. So
Tell him I said hi.
I will. But I have to say it was a great game. They had the ball in our territory, less than 2 minutes left. We had a 3-point lead in what was then a 55-52 football game. So I've never seen anything quite like it. It was a heck of a game. But thank you very much. I can't tell you that I'm an expert on hydroelectric power. We don't have a lot of it in Oklahoma, as you can imagine, a little bit in the eastern part of the state, and nothing on the scale that you have in the Northwest. I am concerned. When I got to my office today, and we had multiple contacts from Indian tribes about this legislation, that they were extremely worried, and actually to Mr. Rush's point, that they might be heard, but they wouldn't have much in the way of input. And that they could be pretty easily dealt out of the process. So I want to give my friend, because again, I haven't read the bill. This was just like you walk in, it's your first day back, and all of a sudden, boom, here's this concern. So I'd like both of you to comment on it. And I want to throw one other thing out there. You know, I also sit on the Interior Appropriations Subcommittee, and I can tell you there is a sad history of ignoring what tribes had to say about dams, because we've paid hundreds of millions of dollars to take down dams that blocked salmon runs and things like that, that tribes told us at the time, don't do this, but we moved right ahead, we generated a lot of power, and then we had to come back and clean up a mess that we had made. So I do have a big concern here, and I want to give my friend an opportunity to respond to it, and then obviously my friend from Illinois an opportunity to speak to it as well.
I thank the gentleman for his comments, and I know his passion on these issues, and it's one we've shared on different issues over time, including the Violence Against Women Act and other things. And I know in the Northwest, we're home to some of those battles over time, and we could all learn something from history. One of the things we could learn is that when an agreement is made, it should be kept. And right now, we're in a bit of a battle over funding for housing that was promised as a result of some of the agreements when those dams were first constructed, dating back to the 1930s. And that tribal housing has never been built in full. And that's something I think that this Congress should recognize was a deal's a deal, agreement's an agreement, and at some point, we need to fulfill that agreement. Now, let me move on to this bill. This bill recognizes, we believe, recognizes and preserves the ability for Indian tribes to participate in the licensing process. And in fact, in some areas of the bill, we actually extended additional benefits to Indian tribes, such as voluntary funding to support tribal participation. We have some tribes that are supportive, some that are neutral, and some that are opposed. We did what we could to try and find, again, common ground where we could get everybody on board. We did not achieve that, but we achieved kind of a mix here of different tribes having different views on it. But I think overall our goal was to make sure they were included in the process in an appropriate way, and that in some cases we actually extended additional benefits and voluntary funding to support tribal participation.
Well, I know my friend has an excellent record on these issues, and there's no question about that, and I appreciate that. And I've not heard from tribes that were supportive. There may well be some there. It's not uncommon for different tribes to have different points of view, as you know. But I just want to note that I have concern here, and I am going to look at it a little bit further. I want to give my friend from Illinois an opportunity.
I want to thank you, my friend from Oklahoma, and as I have stated to you on many occasions, there are 3 states in this nation that are my favorite states. Georgia, the state in which I was born, Illinois, the state in which I lived most of my life, and Oklahoma, the state in which I served in the military. So I share your concern and your appreciation for the great state of Oklahoma. But to address some of the issues, the bill is structured is such that it overturns key court decisions that affirm the authority of states over FERC with respect to water quality decisions and the authorities of federal resource agencies to impose conditions to protect federal and tribal resources. The bill expands FERC's authority to intervene and override tribal, state, and federal resource agencies authorities under the Clean Water Act, the Endangered Species Act, the Historic Preservation Act, and many others that are the basis for conditions to be applied or renewed, applied to renewed licenses. The bill strictly defines licensing processing schedule, applies absolutely no discipline to the license applicant, only to states and tribes and federal resource agencies. The timelines are set and enforced by FERC, and the time period designated in the bill are too short for comprehensive studies to be completed that will support strong resource and cultural protection. It's important to remember that hydro electric licensing expand terms of 30 to 50 years and never truly expire. After the term is up, existing law grants a license holder annual extensions in perpetuity without even having to apply. The bill expands and alters the trial type. This is very important. The trial type hearing provisions of the Federal Power Act to provide industry with multiple new points to challenge conditions designed by federal resource agencies. The concern is that the threat of these hearings, which are time and resource intensive, will be used to get agencies to propose weaker, fewer conditions. And the bill also shifts the venue for these visits to FERC, a venue much preferred by industry. And lastly, Mr. Chairman, several tribal nations, including the Yakama, the Puyallup, and the Sokomish tribes have expressed their serious concerns about the impacts of this bill on tribal land and water rights. And Mr. Chairman, that said, I know that the tribal nations, the states, and others are deeply concerned about the provision of this bill, particularly and especially because it prohibits them from full protection of current law.
Well, I appreciate that, and I won't take any more time. I just wanted to note my concern, and, frankly, I hope this debate carries out on the floor. I think it's an important debate and discussion to have, so I hope the appropriate amendments made in order so that that can happen. And it will matter to me what I find out, and I would welcome any additional information that either the two gentlemen could get to our office on this, because again, I do admit I'm coming to this pretty cold just on the basis of what I heard today, and I have enormous respect for my friend from Oregon and his committee and the serious nature in which they approach all their business. So I just this one's concerning to me. My friend from Illinois raised some of those concerns. So
Chairman yield.
I certainly yield to my friend.
I want to join in with the gentleman from Oklahoma and acknowledge not only what he has brought up, but also Mr. Rush and the confidence by which the chairman has in this. I've read pages 3 and 4 that detail much of the contact that we're talking about, including language that would require states and tribes and others to accurately or to identify as quickly as possible any problems that they might have in that delineation of that. What I would ask the chairman, if I could, is if he could consider, and you do not have to publicly commit to this today, but I think it's a request from this committee that we would request that you would establish within 2 years after the signing of this bill, where you would hold a hearing specifically to take in feedback on this issue from at least tribes. And you do not have to commit to that, Chairman Walden, but I would like to say that I think that would really be good. I'd like to think that what you're doing here would be in the best interest, but I will tell you, year after year, I see people that try and roll our tribes that have our Native Americans, and there are lots of processes used. And I'd like to see you, as you fill out your obligations to the Congress, to hold a hearing in a couple of years and make sure exactly the same things that Chairman Cole and I talk about. So I thank you very much.
Oh, thank you, Mr. Chairman. And again, I want to make it crystal clear to my friend, I know this would not be the intent. I just know enough history.
Sure.
My friend cited some of it to know that these things happen. And again, going through a consultation as opposed to having a role in the decision-making are two very different things. There's too much history here in our country about, basically, hearing but not listening and just moving right ahead. And again, we've paid the price for that ourselves. Federal taxpayers paid the price for that on multiple occasions. I've gone to these dams, and some of them in the Northwest, literally the year before they were going to be torn down, having been built at great public expense and then removed because of what the ecological consequences were. And again, we were warned, at least I was told we were warned in those occasions by the affected entities. So I just want to be careful here.
Yep.
And again, I know my friend is very careful as a legislator and is always serious, and I know his record on these issues, which I value and praise highly. But I'm going to thank, too, my friend from Illinois for raising the issue, important issue to raise. With that, I yield back, Mr. Chairman.
Thank you very much, Chairman Cole. Ms. Slaughter.
Thank you. I'm a great proponent of hydropower. I served over Niagara Falls, one of my many movings around in reapportionment. Wanted to put low-head hydro in the Niagara River, pretty distant from the falls. Worked really hard on that. But we are aware that a lot of people are opposing this, not that they don't like hydro, but they're not sure that you're helping. So with that, I'll yield back my time.
Yes, ma'am. Thank you very much. The gentleman from Georgia does not seek time. The gentleman from Massachusetts.
Mr. Chairman, I just like to ask unanimous consent to insert in the record a number of letters from tribes all over the country that object to this legislation. And while I appreciate your comment that there should be a hearing in a couple of years that includes tribes, it's my understanding the Democrats on the committee asked that tribes be allowed to testify and were denied. So I think it would have been better if we had done it the other way. But with that, I yield back.
Without objection,
Mr.
excuse me just a moment, please. Does gentleman seek more time?
No, but if the gentleman wants to.
My staff said we did not get a request for tribes to testify, so I don't know. I just like to stipulate that.
Yeah, my understanding is that it was sent, so.
All right.
Yeah, so
Happy to.
it would have been better
Yeah.
if it went that way instead of what you're suggesting. I yield back.
Thank you very much. Gentleman yields back his time. Thank you very much for adding those letters. I will be following up and making sure Chairman Cole and I receive those letters to specifically address this, as we would want to make sure that what we're doing is the right thing to our land and resources. Gentleman from Louisville, Texas, Dr. Burgess.
Thank you, Mr. Chairman. And I will say, from the full committee perspective and the markup on this, I think it was a very open process. I think one of the concerns that came up is, would there be proper protections for environmental and health concerns? Mr. Chairman, would you care to speak to that?
Yes, happy to do that. And in fact, the bill clearly makes the point that existing environmental laws are to be upheld, period. Clean Water Act, the Endangered Species Act, these other laws are in place for a reason, and it expressly preserves through a strong savings clause that all requirements of the Endangered Species Act, the Clean Water Act, the National Historic Preservation Act, and other federal environmental programs are preserved in here. It promotes collaboration and dispute resolution to find new efficiencies without infringing on agency authorities.
Just as I remembered it. So thank you, Mr. Chairman. And again, it was, as far as the full committee markup, it was an open process, and everyone was given an opportunity to be heard. And
we had multiple hearings throughout the process. And to the chairman's point, Mr. Chairman, I would make this commitment that my view on passing legislation is that's just where you start. It's seeing how a law is enacted and carried out that really matters. And so it would be my intention to, if this becomes law, to go back at some point and look to see how it's working. If there's a problem, bring it to us. We'll take it up.
very well. I yield back,
Gentleman
Mr.
yields
Chairman.
back his time. Thank you very much. By the way, I believe the hearing you're talking about was May 3rd of this year.
Your memory is better than mine, Mr.
Well,
Chairman.
it's a
but
memory. I
I'll-
don't know how great it is, but it was done this year and very timely. And
Mr. Chairman,
Yes, sir.
I might add, this has been a pretty lengthy process in terms of the full committee. And we were, the minority side, were really in serious discussions and negotiation with the majority side. But there was a failure to include the minority viewpoint at a critical time. And so negotiations came to a screeching halt,
Yes,
all right, because we weren't being heard. And I feel that that's what is going to happen once this, if this bill is enacted. It will become law, and the fact is that the states and the tribes and other federal agencies, they will won't be heard. They won't be taken. Their viewpoints won't be taken into consideration. And Mr. Chairman, I guarantee you that I know how these things go. I have some idea how they go, and if this becomes law, then there will be some serious problems that will be felt by the tribes and the states and other federal entities. There will be some, because they will have lose their right and the privilege to be heard, because this will become law and there will not be any redress to it, in my opinion.
Yes, sir. Well, I have looked at, as I generally try and do as I read the report, page 43, 44, 45, that specifically did delineate dissenting views that were offered to the committee. And most of the time, what I saw in reading them was a disagreement about timeframes of 60, 90, and 120 days. And yet I moved to the front of the bill as I read it, page 3, 4, and 5, that repeatedly asked for early on from an application perspective that any possible dissenting views, any possible concerns from either the federal government, the state government, the local government, or a tribe would be asked for and encouraged early on in the process. And I believe that what the disagreements really here are about whether we're going to get it done or wait 10 years to do it. And I think that that is overwhelming evidence that what Mr. Walden is trying to do here is to get projects done in our lifetime as opposed to continuing them ad infinitum.
And Mr. Chairman, if you go to page 18 of
Mr.
that,
Walden, you're recognized.
you would find too that I'll shorten this a bit, but the commission can grant an extension if the agency or Indian tribe demonstrates that complying with the schedule, which you raised, would prevent the agency or Indian tribe from complying with applicable federal or state law. So we don't run over the top of federal or
Which was
state law
what the
by the
point of
schedule.
page 3 was about. Please tell us early
Right.
on if you think you might have it, and
Exactly
then
it.
that way we can
Let's work together from the beginning,
I
try and
think
resolve
that's-
these things, but if we need more time, either state or federal agencies or tribes can get an extension.
Anyway, that's what I read. It's mostly the timeframes or the dissenting views. Thank you very much. The gentleman from the state of Washington, Mr. Newhouse.
Thank you, Mr. Chairman. Being from the state of Washington, the Pacific Northwest, just as much as Chairman Walden, we have hydropower is our thing. This is the engine that drives our economy. It's a clean, renewable source of energy that unfortunately is not as prevalent around the country as it could be. And so, in my estimation, anything that we can do to allow and improve the utilization of this clean, renewable source of energy is something that is a positive thing. What I read this bill to do is just to designate the FERC, the Federal Energy Regulatory Commission, as the lead agency around the country so that there's consistency in these permitting processes, in granting or renewing permits. And I also read the language that specifically should address the concerns of a lot of people that I'm hearing, that it's these reforms will have no effect on either the Clean Water Act, the Fish and Wildlife Coordination Act, the Endangered Species Act, the Rivers and Harbors Act, or the National Historic Preservation Act. All efforts are being made to make sure that current law as it exists is complied with. That's one of FERC's main responsibilities, I believe, and that state and local issues are considered. I think this makes a lot of sense to allow our nation to realize the true benefit of harnessing clean, renewable energy in this country. And so I don't necessarily have a question, but I would ask the chairman maybe to let me know if I'm reading something in here that isn't. Am I interpreting the intent and the impact of what this legislation does correctly?
Yeah, I think so, because he's a good student of legislation, both the state and federal level, and so I believe you've read it correctly. Fundamentally, hydropower is a really important part of our energy mix, and in certain regions, it's even more important part of the energy mix. Many of these hydro facilities are going to be up for relicensing. We know that they can take 7 to 10 years to get a permit renewed just to keep doing what they're doing. It is important, because these are long-term licenses, that affected parties, communities, individuals, agencies, tribes, state, federal, should all be part of that. That's why this tries to say we have a lead agency in the Federal Energy Regulatory Commission. This is their job to do the licensing. And second, that you get together ahead of time and say, let's see what issues need to be on the table and discussed. Let's all get together. That's the preview meetings and all. Then we set a schedule everybody agrees to work by. And unless you bump up against a timeline that would preclude you from meeting federal and state law, the process moves forward. So the idea here is to get to a more time-based outcome that still respects underlying federal law, especially Endangered Species Act, the Historic Preservation Act, the Clean Water Act. All these things are bedrock environmental and important laws. Those are all maintained in here. But in the past, these relicensings go on for a decade or more and just sort of wander around and never get resolved. We're trying to put some sideboards around this. I can't imagine when this process was first created, it was intended to last a decade.
And isn't there, or shouldn't there be, and I'll let Mr. Rush respond as well, but I know in my district, the utilities that have to go through these processes, like you say, can last 7 to 10 years. The cost to the ratepayers of these utilities is tremendous.
Tens of millions of dollars. And you know who pays that are men and women that are writing the check every month to the power company.
Exactly.
And that's why I think we tried to find a good basis. And in many cases, I think, and my friend Mr. Rush should probably agree, we found common ground on a lot of the points, just not on the final points. Yeah. But hydro is an important part of our mix. It's an important part going forward. It integrates well with other intermittent renewables, because hydro storage can act like a battery. We know that with the closed loops on pump storage capabilities. And all the agencies that independently review situations say that there's incredible untapped hydro energy capabilities out there. So if you want to transition to a low carbon future, if you want more renewable energy, there are dams in existence that we could hook more generators to, and without changing anything really significantly, be able to generate completely pollution-free electricity. That should be a goal we share. We want to make sure others involved have a chance to participate. But a decade and tens of millions of dollars,
it's not going to happen.
It's going to put some existing projects at risk, and then they will look. If you price hydro out of the market, you replace it most likely with a carbon-based fuel. By 2030, more than 400 projects and 18,700 megawatts of capacity will begin the relicensing process. So we have an opportunity, as we've done, to review existing statutes to say what's working and what's not, and then try and find a common ground on a thoughtful way forward to streamline a process that, frankly, has just been out of control.
Mr. Rush, would you have any comments?
Yeah, I certainly do, and I want to thank the gentleman for allowing me to respond. Mr. Chairman, that is really, FERC itself, the agency that's under this legislation that will be charged with enforcing this legislation and implementing it, FERC itself disputes the claims that the bill will streamline the licensing process, noting that the legislation, and I quote, could increase the complexity and length of the licensing process. This is what FERC has to say about this bill. H.R. 3043, Mr. Chairman, also does not address a major cause of delay according to FERC in the licensing and relicensing process. And the major cause, according to FERC, is an applicant's failure to provide all information necessary for federal resource agencies, states, and tribes to make timely decisions. The applicant themselves are responsible for over 2/3 of the delays of the application that is before FERC. Disputes over studies and information required to fulfill the obligation of all regulatory parties in the license process are often another source of delay. FERC has frequently dismissed requests by resource agencies and states for studies to enable them to issue legally defensible decisions or permits under their statutory authority. And even more importantly, Mr. Chairman, FERC has often omitted license conditions proposed by state resource agencies under the Clean Water Act because it has deemed them late or contrary to some conclusion reached by FERC, an agency with no real expertise in natural resource management. FERC is a divorce attorney and not a criminal attorney. They don't have the expertise, but they have all the power. They're the judge and the jury. Just recently, FERC sparked a huge controversy by failing to include in a license condition proposed by the state of West Virginia because FERC decided that the state was late in acting, even though West Virginia acted less than a year after receiving a completed application for a water quality certificate from the project developers. Mr. Chairman, FERC can't do this. FERC don't have the capacity. They're not charged with it. They wasn't created for this. This is not a FERC issue, not a FERC responsibility. And we're handing it over to FERC, and there's no reason other than the fact that FERC is friendly to business. That's the only reason.
So, Mr. Chairman, reclaiming my time, Mr. Rush makes a good point, and looking at the testimony that was heard in the committee, there's the agency itself said that in many instances it is applicants, federal and state agencies, as well as other stakeholders that determine project success and control whether a regulatory process can be short or long, simple or complex. However, they go on to say that, and I think this is part of the intent of the bill, that FERC lacks the authority to improve the hydropower licensing process by helping to resolve the disputes among agencies and enforce scheduling deadlines. So we're trying to help the process, help this 7 to 10 year time that it requires to relicense facilities or to grant new ones. And so, like I said before, this is a tremendously important source of energy, clean, renewable, carbonless. We have tremendous potential in this country. A lot of dams exist that have little or no generating capacity. If we can utilize this source of energy, we should do all we can to do that. And I certainly further want to understand the concerns, certainly as relates to some of the Indian nations that have expressed concern over this. I don't know what they are. Some are okay with it, some are maybe on the fence, and others maybe have some concerns, but I'm certainly open to hearing those. But I would encourage strong consideration of this bill, and I appreciate the opportunity to hear from our two gentlemen here presenting their testimony. Thank you, Mr. Chairman.
Thank you very much, the gentleman, Mr. Buck, does not see. Gentlemen, I'm going to boil down at least what the chairman said, kind of an Eagle Scout thing. I see Mr. Garamendi, an Eagle Scout, that's here, Mr. Walden. We have a saying in scouting that goes something like, take all the time you need and make a quick decision. I think that the application of what you're trying to do here, Chairman Walden, is take the time you need, make a wise decision, include people and let them know up front they're going to be encouraged to participate. As a matter of fact, get a letter back from them day 30 saying you got invited to where you can't act like you didn't know. And then if you don't get that letter, somebody will go to them and say, just so you know, we're planning on doing this. Get everybody to row together and then be responsible for getting it done. I think it's an important attribute about starting and finishing a project, but sizing it up properly. So I want to thank both of you for taking time to be here today. Mr. Rush?
Yeah, Mr. Chairman, I just want to, on the issue of, on letters, and whether or not letters will be addressed, on the April 27th, Mr. Pallone, myself, and other colleagues sent a letter to my friend Chairman Walden and Chairman Upton requesting a hearing with tribes and state and resource agencies, and our request was never ever granted and responded to. So
They did not respond back to you.
Mr.
no, we have not today. We have not heard a response.
Yes, yes, sir. Chairman Walden?
Mr. Chairman, and on May 3rd, we had a hearing, so I guess, we had and the Democrats had an
With
opportunity
tribes?
to,
With representatives from the tribes?
we left it up to Mr. Rush, Mr. Pallone to select the two witnesses for the minority, and we selected two witnesses for the minority. I don't think a tribal member was requested by either party at that particular hearing, so.
Well, I'd like
I
for
certainly don't agree with that interpretation of the process, Mr. Chairman. We wanted a hearing whereby it was designated by the majority that the tribes and the states and the resource agencies would be invited to appear before the full committee for a hearing. And that letter and that request was never even addressed.
Yes, sir. The record would reflect on page 13 of the committee report that there was committee action on May 3rd. The subcommittee received testimony, and then it talks about those 6 or 7 people. And I'm sure that there is a way to not only hear from tribes, I'm sure we will, and would also, as the gentleman, Mr. Walden, has suggested, that he would naturally follow up on pieces of legislation that were done and ensure compliance. I don't think in any mean or measure you would intend for FERC or anyone else not to be in full compliance with your wishes, Mr. Chairman.
Correct.
Great, thank you.
Thank you, Mr. Chairman.
Mr. Rush, I want to thank you and Chairman Walden for being here. Is there any other committee member? Mrs. Cheney, do you seek to have any time with the gentleman?
Thank you, Mr. Chairman. I would just echo the concerns that my friend from Oklahoma raised about the tribes, and would look forward to getting some additional information and make sure that our tribes are not feeling like they're shortchanged by the legislation. Thank you. I yield back.
Thank you very much. It seems as though all of the members have had an opportunity to speak with both of you. I want to thank both of you for your time and your interest. Mr. Rush, you did well enough to come back again. Mr. Walden, you're the same. If you'll please make sure that anything you brought in writing would be available to our awesome stenographer who would be able to complete the transcript of today's hearing. Thank you very much. Now I'm going to move to the second panel that would be here. Thank you very much. The gentleman from Texas, Mr. Babin, the gentleman, the Eagle Scout from California, Mr. Garamendi, the rancher from California, Mr. LaMalfa, and the gentleman from Wisconsin, Mr. Grothman. Gentlemen, thank you very much for joining us. You've been sitting through a good bit of time this afternoon on a bill that did draw a good bit of attention. I'm delighted all four of you are here. Without objection, anything you brought in writing will be entered in the record. And I will, it's my understanding that Mr. Garamendi and Mr. LaMalfa probably have submitted amendments that have each other's names on them. So, gentlemen, you draw straws as to who goes first, but we will defer to the gentleman, Mr. Garamendi, first. The gentleman's recognized. Is that mic on?
I think it is.
There we go. Thank you, sir.
Ready, set. I was hoping Mr. Walden would be here so we could talk about the UC Berkeley Cal Bears and Oregon State, but we'll have to let that go.
What was that score?
Well, let's say it was favorable for the Golden Bears.
Well,
But we'll let that go for now, since we were talking football here earlier. Mr. LaMalfa and I have introduced a amendment that deals with the Oroville Dam, the largest earth-filled dam, highest earth-filled dam in the United States, that came very, very close to failing last year. FERC is considering a license, relicensing the dam, which we hope they do. It's a very important element in the California water system. However, the environmental study was 10 years ago, 2007. As the licensing goes forward, there are some new facts, like the near collapse of the emergency spillway and the potential devastation to more than a couple 100,000 people, including my good colleague. Mr. LaMalfa's ranch would probably be some 10 feet underwater had that spillway collapsed. There are environmental issues associated with the ongoing degradation resulting from the collapse of the spillway. I think you've all seen the pictures. I had a marvelous placard to bring in, but I was told it's not a potential.
that probably is correct.
Thompson.
I noticed you had a run-in with the clerk, Ms. Booth. It looks like she won.
She won.
Okay.
It was a very short confrontation.
I'm 0 and 450, so you're 0 for 1. But in fact, let me acknowledge that she was correct, but I would encourage any of the members that would seek to see the picture of the dam that you have respectfully brought in, that it would be available in our entryway.
This amendment does three things. It would require that a new environmental or supplemental environmental study be done if there have been three factors. First, a presidential disaster declaration resulting safety concerns of the project. Most recently completed environmental review is 10 years old, and FERC has directed an independent board of consultants to conduct a forensic investigation into the causes of the safety concerns that lead to the disaster declaration. Those three requirements make it, well, it's not exactly an earmark because we're not money here, but we have a very specific concern. They need to review this based upon more recent information. Certainly the result of the last February's potential disaster. 200,000 people had to be evacuated. And fortunately, that was done. Fortunately, it didn't rain. The rain stopped. Had it continued for another 3 hours, it could have been a monumental disaster. In any case, that's what it would do, a new, updated environmental review.
Thanks, sir. Mr. LaMalfa?
Thank you, Mr. Chairman and committee members. Mr. Garamendi presented that very well and efficiently. It is a very narrow focus of this amendment here that would directly impact the need for Lake Oroville and the area to have another look at the impact. We have a lot of issues that came from the failure of the main spillway in the amount of silt and material that got into the river and the ability of the river to carry the water that needs to through the system for flood control. It affects Butte County in my area and Mr. Garamendi's just downstream from me with Yuba and Sutter County, as well as other related impacts that could come from the potential. So there's a great need to have a really good look at this once again and not be really hurried into another relicensing, which I completely support. The dam needs to operate, the hydro plant needs to operate. The amount of hydropower that comes from Lake Oroville, when it's fully operating, is almost equal to the amount of electricity it takes to push the water over the Grapevine and supply Southern California. And so this is something that everybody in California needs to have a important look and focus on. So I think this is, again, it's a very narrowly drafted amendment to focus primarily on what we're dealing with on the Lake Oroville project in Butte County. That, again, as our two districts interlock and so much, we're working a lot together on issues with the Feather River, Lake Oroville, as well as the Sacramento River and Lake Shasta and on down to the Delta. So I appreciate the time and your concern
Yes,
of
sir.
the committee.
Yes, sir. Mr. Grothman, if you could please borrow that from Mr. Garamendi, and gentleman's recognized.
We'll try to go quick. One of the things I'd like to bring attention is something that have to be approved by the Secretary of Commerce, Secretary of the Interior, regarding these ways to get fish up over a dam. And we are a little bit afraid, and something that's actually in Congressman Pocan's district, who is also on this bill, that in my district, they may put one of these things up, and as the result, invasive species will get further up the river. I'm talking about, we have Asian carp along the Mississippi River, the southern Wisconsin River. There's a big dam in the Wisconsin River. If they would ever put in one of these fish ladders, those fish could get to northern Wisconsin, destroying our lakes. Given how close the Mississippi River watershed is to the watershed going into the St. Lawrence Seaway, it could even, these fish could even get, invasive species could get in the Great Lakes and destroy those areas as well. So it's a short amendment, just saying that the Department of Interior, Department of Commerce should consider the threat of invasive species. I'm told the chairman and ranking member are both on board. So that's it.
Great, thank you very much, Mr. Grothman. The gentleman from Woodville, Texas, Dr. Babin.
Yes, sir. Thank you, Mr. Chairman, members of the committee. I'll try to make this real quick. I have an issue in my district where we've had repeated floods because of FERC protocols that cannot be mutated, changed, or in any way. And several communities that have repeatedly flooded out. And it's gotten to the point where their people are almost ready for armed insurrection. They have repeatedly asked the Sabine River Authority to please release water before a natural disaster, increase your flood storage capacity. And in the last 2 years, this particular dam has had 2 federally declared flood disasters. One was Hurricane Harvey, and I have the dubious distinction of having the continental rainfall record for North America in my district of 51.88 inches in one storm. Now, it's very difficult to prepare for a storm with 52 inches of rain. But as I said, this has happened repeatedly. And I served on a river authority for 15 years, Lower Neches Valley Authority in East Texas, where I've lived all my life, other than when I went to college and served in the military. And tough decisions have to be made. And a lot of times, you're left with just making a decision between bad and worse, and where you can put all the water that's coming down. But one thing that shouldn't be the case in making these decisions is assumptions based on FERC protocols, federal rules that were set in stone years or even decades before. Lives and property absolutely have to come first. And that's why I filed this amendment, which would make it clear that FERC can and should examine the license of any project located in an area that was affected by a presidentially declared disaster. I'm not sure whether you have this in front of you or not, but I will just read this, that the Federal Energy Regulatory Commission may examine the license issued by the Commission under Part 1 of the Federal Power Act for any project that is located in an area that was declared by the President to be a disaster in this area. Let me just give you a quick example. I live on a ranch in East Texas. I have a lake We knew Hurricane Harvey was on its way. Just using common sense, I lowered the lake level by about 3 feet in my lake, and we saved my lake and my dam, where many, many others were not able to do so. So we've got to have common sense. This does not mandate that FERC come in and review these, every project, but we have certain projects like Toledo Bend Dam, between one of the largest reservoirs in the state of Texas on the Sabine River between Louisiana and Texas that needs to be reviewed. We also have another one. I have 4 major reservoirs and rivers in my district, but the other one is Lake Livingston. But by far the biggest culprit that has raised the ire of many, many thousands of people in my district has been Toledo Bend. And the Sabine River Authority, hands are tied. They are begged by the people living below the dam, please increase your storage capacity, please let some water out, and the FERC protocols do not allow this, and they have repeatedly flooded out. So examining these licenses through the lens of what happened and making the necessary adjustments, if necessary, is the responsible and necessary course of action, and I would greatly, and my constituents would greatly appreciate the opportunity to include this language that would encourage that in this bill. I would yield back.
Dr. Babin, thank you very much. It seems like what you're trying to say is where there's a natural disaster, a presidential declaration, to go back and see it initiates a review, and I think that makes a lot of sense. Mr. LaMalfa, I might show my ignorance. I don't know. The dam that you spoke of, is that the responsibility of FERC or the Corps of Engineers?
Lake Oroville, it's operated by the State Water Project, Department of Water Resources. Army Corps of Engineers oversees the flood control aspect. FERC does a licensing. So there's a lot of cooks in the kitchen on it, so it depends which aspect you're speaking of. The relicensing will be under FERC, but with the input of a lot of other aspects along the way.
Well, I might refer you to a guy named Mike Burgess, who had in Louisville, Texas, a problem. I didn't say similar, but a problem. And he was most effective in trying to work that through. So either way, no matter what happens, you need that backup. So I would encourage you to talk to Mike Burgess. I was involved on that, but I take very seriously what you're talking about, and I want to thank you for being here. Chairman Cole? Gentleman does not seek time. Ms. Slaughter?
I don't have questions either, but I do support your amendments. Hope we can get those made in order.
Thank you.
Gentleman from Massachusetts?
Support your amendments, no questions.
Thank you very much. Anybody seek time from the committee? I want to thank you all very much. If you'll please remember that our awesome stenographer would like to complete the record. Anything you brought in writing will enable her to do that.
Oh, he actually has more he wanted to talk about.
I'm sorry, excuse me.
There's additional, I wasn't sure, Mr. Chairman, thank you for.
You're recognized.
Okay, thank you, sir. And I have an additional amendment on my own, not with Mr.
I
Garamendi.
apologize for
No,
that.
no,
Yes,
no,
sir.
I was,
These two amendments came in a little bit later, and we have not had time to, in honesty, to evaluate them. I think one came in about 3 o'clock, and so I was
I
detained.
appreciate your
this
indulgence on
Yes,
them,
sir.
and
Well,
can make
that's
that-
why you're showing up, too.
Well, it's important, yes, sir. So we had 3 submitted. I'm going to address 2 of them, and
Yes, sir.
number 1 and number 3 of them. I'll rattle through this here, so thank you. The Amendment 1 I'm talking about applies to the closures and the impacts of closing hydroelectric facilities on what the effect will be on surrounding communities, and are they properly considered by FERC when considering an application to surrender a license. So my amendment directs FERC to consider the following impacts to local communities on local revenue, employment, water supply and availability, impacts to energy reliability, impacts to energy prices for regions served by the dam operator, DAM, which is also the loss of the loss of in-state generated renewable power in a time when renewable portfolios keep increasing. So if you're losing a renewable power supply, that needs to be considered as well. In my region, excessive regulations have forced the operator of 4 hydroelectric dams on the Klamath River to consider surrendering their license. The previous administration used the power of the government to force the dam operator to consider this drastic action, despite the owner's preference to keep operating these renewable projects. These dams provide reliable, renewable power at low cost, flood control, water storage, clean, reliable power, local jobs, and significant revenue to the local county, which is a very small, very rural county. It doesn't have a lot of options. Removal of these dams and the power they generate would be devastating for the region, hurt the grid of its renewable supply, yet FERC is currently not required to consider the impacts in any way. Our amendment requires that FERC to look at these impacts to local communities and the whole grid, and that they be fully quantified and make informed decisions when considering basically the forced closure of these facilities. Okay?
Yes, sir.
That's it, what I have on number 1. Number 3, again, this amendment affects primarily the Klamath River, which is in my region. I share part of it with Mr. Walden as well in the 4 dams we're talking about. We've talked about the impact of the removal of the 4 dams on the local government economy. This amendment would prohibit FERC from approving an application to surrender a license unless the following occurs. The Secretary of the Interior submits a letter to FERC stating the closure of the hydroelectric facility will not have negative environmental impacts, which when you're looking at the possibility of 20 million cubic yards of silt being unleashed in the Klamath River, and that has been glossed over in my view, it falls far short. So we could hurt the salmon species purportedly being aided in this process. Secretary of Energy also needs to submit a letter to FERC stating that the closure of the hydro facility will not negatively impact electric supplies or reliability. Trying to speed here. Shifting from reliable renewable power generated 24 hours, 7 days a week, available anytime, to unreliable sources like wind and solar, which can't be counted on at night or when wind's not blowing, will hurt the grid and its reliability. So with that, Mr. Chairman and committee members, thank you for your time.
Mr. Malfa, thank you very much. In fact, some of the issues that you bring up were some of the questions that I had as you spoke, and that is, we talk about building, we don't talk about taking down. We don't talk about the effects of things, and this is part of the dilemma of me focusing on your amendment late this afternoon, and I want to thank all 4 of you. John, as always, thank you for all that you do and showing up, and if you'll keep your picture back there for a little bit, I'll bring it to you on the floor. Gentlemen, thank you very much. We appreciate your time before the committee today.
Okay.
Is there any other member that would seek to be heard on H.R. 3043, Hydropower Policy Modernization Act of 2017? Seeing none, the committee will now welcome back one of our favorites, and that is the gentlewoman who is the chairman of the Committee on Education and Workforce, the gentlewoman from North Carolina, and we're no stranger to Mrs. Fox, and also the gentleman, a dear friend of mine, Bobby Scott from Virginia. And we're starting on votes. I know the gentlewoman recognizes that. We're also very interested in getting to the bottom of this. Without objection, anything you brought in writing will be entered in the record.
Mr. Chairman?
Yes, sir.
If the 2 witnesses are brief, and we promise to ask no questions?
I think all that'll do is help them out.
Thank you.
Thank you. Good point. You've now heard a suggestion. The gentlewoman, does she want to submit her testimony? The gentlewoman's recognized.
Mr. Chairman, I would be more than happy to submit the testimony. This is a bill introduced by Congressman Byrne, one of your own members. And by the way, I'm delighted to be back with the Rules Committee. It is bipartisan. It has 123 co-sponsors to it. It's an extraordinarily short bill. It's 31 lines long, which is, I think, the kind of legislation we should introduce. It's a great bill. It will straighten out a terrible ruling made by the NLRB in a ruling called Brown-Ferris decision. And so I would very much appreciate the committee giving us a rule and making the bill in order for us to be able to bring before our colleagues for a vote. And I'm sorry, we have a wonderful statement the
Well,
staff
we'll
has
still put that in the
prepared.
record.
And the longer statement will go in the record, and I appreciate
Well,
Mr.
Virginia, you're getting your way again with the
Mr.
committee.
McGovern's comments. Thank you.
Yes,
I-
ma'am.
I
By the
yield
way,
back.
Virginia, I normally write it to you, but I'll tell you, I love you and you're beautiful. And thank you very much for being here.
Well, you've added something,
That's
Mr.
public.
Chairman. I love you too.
Well, no, I
And
always
you're
say I
beautiful.
love you. I just didn't say, hey, you look awesome, but you got those, if they're pearls, but you got them on. Tom knows about this. Her husband's well aware. I've written her notes for years when she was up here.
Are you sure?
Oh, she put them in her purse every time. Mr. Scott, welcome.
Well, I'm not going to follow up on those comments. I don't have any idea what's going on, but
Well, I've tried to get the Dallas Morning
It's
News
okay,
to write about it for a long time.
but I have been advised by staff and by the members that we won't have to come back if I'm brief. So
I think you heard
I have
it.
a great statement. I really wanted to read it. I'm sure you will. You did not have a process for amendments, but I offered amendments anyway. This is a joint employer bill which decides when you have a number of possible employers, who's on the hook for National Labor Relations or Fair Labor Standards violations. If somebody hadn't paid overtime, well, who owes it? The joint employers, if they're joint employers, they both owe it. One amendment would prevent the bill from applying if, under the strict definition, nobody's an employer. You find you've worked 40 hours, you worked 50 hours, you're entitled to overtime, and then the judge says, well, you're entitled to overtime. Well, who owes it? Well, nobody qualifies under the definition of employer. Nobody. It just says that if that situation applies, the bill doesn't apply, and you can go back to the traditional way. At least somebody's going to owe you the money. The other is to the ruling that has been referred to, Browning Ferris, isn't even final. It's up on appeal, so we don't know what the final version is going to be. But it replaces that decision with one that in the bill with one that has been common law for decades and decades. The final one would be to hold the franchisor liable if they direct a franchisee on what to do. The franchisee does it. The franchisor ought to be on the hook for the response for the results, not paying overtime or failing to negotiate. I would hope that these amendments would be in order because they would help correct some of the flaws in the bill.
Thank you very much.
I add one quick
Yes,
thing. I at least should give the committee the proper title of the bill we're discussing. It's H.R. 3441, the Save Local Business Act.
Thank you very much. I want to thank both of you. Yes, sir.
And I'd like to introduce a letter from a business organization.
Without objection, that'll be in the
that
record.
outlines how it is unfair to good employers when you allow bad employers to do wage theft and everything else. It makes it an unfair competitive advantage for those that are doing the right things.
Well, I look forward to this opportunity to debate this on the floor. I'm sorry we're trying to rush everything through. We want to thank both of you. Knowing where we are as any member, seek time with a witness, seeing none, so thank you very much.
Afraid to.
Mr. Newhouse? Did you seek time?
Yes, sir.
Well, the gentleman is recognized.
I just wanted to ask unanimous consent to submit for the record some letters of support from different organizations. First,
Without objection.
I have the National Retail Federation's Coalition for a Democratic Workplace, which includes the Washington Hospital Association, as well as the Washington Retail Association, National Federation of Independent Business, the International Franchise Association, Independent Electrical Contractors, and also the American Bakers Association. Mr. Chairman, I appreciate your indulgence and would ask for strong consideration.
Thank you very much. By the way, Mr. Newhouse, it's my understanding that you have a special guest. I know we're trying to do this. Sean O'Brien has his mother visiting next to Caroline Booth in the back. So welcome. We're delighted that you're here. Thank you very much. Without objection,
Mr.
lay
Chairman?
that in the record. Yes, sir.
I know you want to know that Sean's mother, Miss Jan Smith, is from Frisco, Texas.
That's home of the Star. The Star. That's Dallas Cowboys. Thank you very much, Mr. Scott.
Mr. Chairman, Mr. Byrne has put a lot of work into this bill, and I look forward to a very vigorous debate. We disagree on it, but since we have a truncated proceeding, I didn't want his good work to go unnoticed.
Well, it did not, and I'm fired up about it too, and we were going to let him, it was going to be Bradley Byrne Day here at the committee, but we didn't make it, so it's Virginia Fox Day. Thank you very much. I want to thank both of you for taking time to be here. This now closes the hearing portion of H.R. 3043 as we've done in H.R. 3441, Save Local Business Act. Chair will now be in receipt of a motion from the distinguished gentleman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 3043, the Hydropower Policy Modernization Act of 2017.
Committee needs, please suspend. Our stenographer cannot hear if she, and cannot complete her work if the gentleman is not allowed full access. Gentleman may continue.
The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment, the amendment in the nature of a substitute, recommended by the Committee on Energy and Commerce, now printed in the bill, and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes an order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to demand for division of the question. The rule waives all points of order against amendments printed in the report. The rule provides one motion to recommit with or without instruction. Section 2 of the rule provides for consideration of H.R. 3441, the Save Local Business Act, under a closed rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member, Committee on Education and the Workforce. The rule waives all points of order against consideration of the bill. The rule provides the amendment in the nature of a substitute recommended by the Committee on Education and the Workforce, now printed in the bill, shall be considered as adopted, and that the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. Finally, the rule provides one motion to recommit with or without instructions.
I thank the gentleman for his motion. This is two bills, one rule. H.R. 3043 and H.R. 3441 is now open to amendment or discussion.
Thank you, Mr. Chairman. Mr. Chairman, I have an amendment to the rule. I move the committee grant H.R. 3441 and H.R. 3043, each an open rule, so that all members have the opportunity to offer amendments to the bills on the floor. And I would like to note that this is the 49th closed rule, which hereby, at this moment, breaks the record for most closed rules in a session of Congress since about the late 1700s.
Wow.
How about that?
Discussion. Okay, the vote will now be on slaughter amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no.
No. Roll call.
Those have gentlemen ask for roll call vote. Clerk will poll the committee.
Mr. Cole? No. Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Collins? No. Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Mr. Buck? No. Mr. Buck, no. Ms. Cheney? Ms. Cheney, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Mr. Polis? Mr. Chairman?
No.
Mr. Chairman?
Clerk report
no.
total.
2 yeas, 9 nays.
The amendment's not agreed to, not agreed to. Further amendments or
No further
no
amendments.
further amendments. The vote will now be on the motion from the gentleman, distinguished gentleman from Oklahoma. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
Ayes have it, ayes have it.
Roll call, please.
Gentlewoman asked for roll call vote. Clerk will poll the committee.
Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Collins? Mr. Collins, aye. Mr. Byrne? Mr. Byrne, aye. Mr. Newhouse? Mr. Newhouse, aye. Mr. Buck? Mr. Buck, aye. Ms. Cheney? Ms. Cheney, aye. Ms. Slaughter?
No.
Ms. Slaughter, no. Mr. McGovern? No. Mr. McGovern, no. Mr. Hastings? Mr. Polis? Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk report the total.
9 yeas, 2 nays.
The motion is agreed to accordingly. The gentleman, the distinguished gentleman from Alabama, Mr. Byrne, will be handling this. Please be advised that our next hearing is scheduled for tomorrow at 3 o'clock. We'll be meeting on H.R. 2201, the Micro Offering Safe Harbor Act, and H.R. 2874, the 21st Century Flood Reform Act. This completes our work for the day. I want to
Well,
thank each of our witnesses. Yes,
Mr.
ma'am.
McGovern will appear for us.
Mr. McGovern will be there for Democrats of Mr. Byrne. Thank you very much.